On the Resources Council. I was the VNRC's representative on the NRC steering committee. A long history with Act 250. I was the Act 250 attorney for ANR for 5-6 years in the mid-90s, and I was the chair of the NRB for a time during the Shulman administration. Been involved in many Act 250 projects, even with VNRC, district commissions, the old environmental board, court. So I bring all that to this testimony. So first, I want to say thank you to Ellen and thank you, Senator Bray, for getting a good draft. It's a really good start, and I really appreciate it. And I think we have something that we can really work with and shape. Obviously, it needs to be shaped, but it's a really good start. So thank you for doing that. Thank you to Ellen for all the work she put into it. So unlike Charlie, I'm not going to cite the page numbers because there's too many page numbers. So I'm going to go topic area and just, like you said, Senator Bray, like kind of impressions, like what is in there, to focus on what is not in there, what some thoughts about, clarity to some of the sections. So the first issue in the bill that's addressed is transforming the Natural Resources Board to the Environmental Review Board and giving it significant new responsibilities. Most, I think, importantly, hearing the designations for the tiered areas that we've heard a lot about again this morning, the tier 1A, 1B, and then tier 3, and also hearing appeals. So that is in the bill. We very much support giving all that authority to this new environmental review board. As I said when I testified on the NRB steering committee report, the report is agnostic on appeals. Right now, appeals with Act 250 permits go the environmental division of the Vermont Superior Court. That change was made in 2004 when the environmental board was eliminated. Natural Resources Board was created. I encourage you, all I'll say about that is VNRC very much supports that. I encourage you to have hearings about who should hear appeals. VNRC's done a lot of research over the last, 10 years on comparing the old environmental board's record, both substantively and in efficiency and speed of hearing appeals versus the environmental division. And if you have a hearing on it, I'll provide the data. But the data is the old board was almost twice as fast as out of the court, and the decisions are much more substantive in terms of stating and you heard of some of this from Ron Wilmington when he testified at your joint hearing. I think he did a really good job of articulating this, but the old board in its decision would really provide clarity about how to implement the criteria. And in my view, it's as simple as that board, they would eat, drink, and sleep Act 250. That's what they did. They were only focused on that. The environmental division, judges, they do a great job, and this is not a slight on the court at all, but they have ANR appeals, they have Act 250 appeals, they have zoning appeals, they have enforcement among all of those programs. Their docket is huge. They have 2 judges and limited staff and a lot more than Act 250. So it's not surprising to me that a board set up to focus on Act 250, to be an expert in Act 250, would do better both substantively and in terms of the speed of making decisions. So, but anyway, I just want to note this in the bill, we really support it. Also in that bill, is an appointment process of the new board members that would really create an independent board, like the old environmental board was. And we very much support that. This is language that the House has passed a couple of times. I think there was a bill that passed both the House and Senate with that language in there. The governor vetoed that bill a couple of years ago. And I think that's where that language comes from. It's been really worked over by the House in particular. I want to flag that. And again, not consensus in the NRB report for that, but something that we support.
It is coming on Groundhog Day, and there's a certain Groundhog Day feeling in some of these issues, like we come at them multiple times. I have a beginner question. Can you remind me what things are sent to Superior Court? I forget the court structure.
In the environmental division?
Well, like what's Superior Court? Why are these the environmental division of Superior Court? Like where's Superior Court sit that it ended up coming to home for these?
It's a good question, and this is one of the challenges with having, so the environmental division, like a specialized court within the Superior Court. The Superior Court hears all civil matters, basically, which are contract disputes, personal injury, tort disputes, they hear contract disputes, family law issues, the whole range of family law issues. And before 2004, they heard zoning cases, zoning appeals were part of that Superior Court portfolio, which is very common throughout the country. Zoning appeals generally go to Superior Courts throughout the country, and then so civil matters in Superior Court, they get appealed to the Vermont Supreme Court, and they make the final decision in Vermont. The policy decision was made in 2004 to add to that portfolio Act 250 appeals and A&R permit appeals. We used to have the Environmental Board for Act 250, you had the Water Resources Board that heard all the water appeals. There was a waste facility panel that heard appeals having to do with waste management issues, and it was all consolidated in the court, really expanding its docket and enforcement of all those programs. So enforcement goes there. But does that provide some clarity or?
And that was just so during the Douglas administration.
It was it was during the Douglas administration, it was the beginning. It came out of a giant permit reform bill that would have really revamped the whole system of especially zoning and Act 250. And really the only thing that survived was basically getting rid of the Environmental Board, the Water Resources Board, the Waste Facility Panel, and sending those appeals to the Environmental Division, a specialized division of the Superior Court.
So the Environmental Board, in addition to, so that's where appeals went from a local for
District Commission.
District Commission
Yeah.
decisions could be appealed to the Environmental Board.
That's correct.
In addition to sort of hearing appeal, did you also more proactively write policy at the EVs?
Yeah, I think it kind of went hand in hand, and it's hard to explain, but I think through the decisions, the board was able to make policy direction, and I think so. The NRB report, there's agreement on half of this, right? So there was agreement in the report to create a professional NRB that are experts in Act 250 that can be more engaged in policy in Act 250, provide more guidance to the district commission, maybe use rulemaking to provide some more guidance. I think that would help, regardless of appeal. But the former Environmental Board was that sort of expert board, and they were able to provide more guidance, but through their decisions, through rulemaking. And I think that the NRB acknowledged, and we talked about this in the steering committee, that the board is just not as engaged. They don't meet a lot, they're not really involved with the administration of the program, and so they're not providing that sort of policy guidance, and that could lead to concerns about the lack of consistency among the districts and clarity, in terms of what's required. Because as you've heard, there are 10 criteria in Act 250, there are over 30 criteria when you add all the sub criteria, and then they don't say a lot, right? Like no undue water pollution, no undue air pollution, no unreasonable traffic conditions, so you need that clarity, right? And the expert board formally did, I think, provide that clarity. And so that's what we're trying to get back to.
Was the EB housed and/or staffed at the NRB?
Yes, it's basically the NRB staff plus some new professional board members that are the chairs full-time like now, but then two part-time board members, and then at least one more staff attorney. And so yes, they would be staffed and they would perform, the existing staff is good, and they would just be beefed up basically. So that's the first part. So just knowing that you could, when Ellen does a walkthrough, you can decide how deep you want to get into that. Kind of moving through the bill, then there's the tiers, right? 1A, 1B, you've heard a lot about. What I want to say about 1A and 1B, so we do have suggestions about, for 1A, the NRB report says is the core area like that now is around the downtowns and village centers, basically. So those programs that we had here, Chris and Jacob just talked about those programs, but those existing downtown village center programs, it's those areas, and then an area around those core areas. What the NRB report says is to accommodate 20 years of growth that's projected. So the RPCs will be mapping these areas based on that charge, I think we need to define like how we're analyzing the 20 years of growth. I think we need to have some sideboards around how that analysis is going to occur. I don't think it would be too difficult to create those sideboards. I think you should ask the RPCs about that. You should have Ryan Shute in to talk about it from a planning perspective. But I think we need some sideboards around 1A. There are some of that in the bill that Ellen drafted. I think Ellen created a good start, you know, in terms of what the criteria would be. But I think we really need to go through each of those criteria, say, are those the right criteria, and kind of how we're doing this analysis of kind of how we're creating this mass area. Importantly, and this came up today, and Charlie mentioned this, I think Ellen, I think she showed one good path to dealing with the flood issues when you're mapping out these areas, saying that you would exclude river corridors, floodplains. We do have experience with this, the current neighborhood development area designation program, which was the last designation program we created, actually said you have to exclude streams and riparian areas, you know, flood areas, wetlands. You basically map them out of the area. So we do know how to do that. I definitely, obviously, I'm gonna talk about this again when I get to the tier 3. S213, I think, if passed in a robust form, will help with this as well, because the state will be regulating all development, right, within river corridors. We'll have better regulation of development in terms of wetlands. We'll begin to start regulating development in along riparian areas of the main tributaries. That's all in S213, the last version that you have created, the version that A&R commented on, and obviously laid out a host of concerns about. But if you kind of stick to really where you're headed, I think that would be just another check on that, right? Because the state would be regulating in those areas. So there is this direct connection between your work on S213 and Tier 1A, how we're kind of dealing with those resources and those flood issues.
What can you, right, I hear them, I read them, they make sense, but I'm not sure I have a good picture in my head of what they look like. 1B, so what can you say a little more about what?
So-
1A really corresponds more to like the designated areas we already have, plus some envelope around.
A wider envelope, because the premise is, as you heard from Charlie and previously, that, and Ellen has this in her draft, like you have to have zoning and subdivision and they have to meet quality criteria. So there'll be an evaluation by the, you know, in the bill, the environmental review board, the reformed NRB, for the quality of the zoning and the ability of the town to administer that zoning. And these are our larger communities. This is Montpelier, it is Barry, it's Burlington, it's the Chittenden County towns around Burlington, Brattleboro and Rutland, and probably White River Junction, but we do need to really hone in on those quality criteria. It's a little squishy, I think, in the bill as it's drafted right now, but that's the concept, is that, you know, 1A can have the wider area, the accommodating of 20 years of growth, because those towns are gonna get a real scrub in terms of the quality of the zoning and subdivision and the capacity to administer those programs. 1B is for the smaller towns that they'll have zoning and subdivision, the way the NRB report is written, and this has been in testimony, people have been a little vague about this, but the NRB report says, and this could be altered, obviously, is you have to have zoning and subdivision of water, but you don't have to have sewer. You can have some alternative to a wastewater system if you can show you have soils that could accommodate growth. And it doesn't say what the map there, it doesn't say to accommodate 20 years of growth. And so our recommendation on that is the neighborhood development area designation, which I just mentioned, allows for sort of a core area in the downtown or village center. 1B will be a lot of village centers, I think, and a quarter mile around. And I think we think that is a fair criteria for 1B. You know, tighten it from the 1A areas, but because those towns won't have the same quality of zoning and subdivision and ability to administer those programs, and they don't have the same needs for growth, quite frankly, they're smaller areas. So we put that on the table. You should get testimony on that, but that's not specified in the report, but it's something that we thought about. It's not in Ellen's draft.
Sarah, what's-
Sorry, so that. So the 1B. Designation as it's written right now does not have this, basically the NDA.
Definitely have that, yeah.
Yeah, plus the quarter mile, but that's what you're suggesting.
Yeah, first, yes.
Oh,
I wanna say, I don't wanna use the rest of my time to talk about combined sewer overflows, but I wanna say something about it. And I think you could have a whole, at least part of the day's hearing on it, but here's what I will say. I think it's a fair point, that, it is this conundrum we have. Some of our largest municipalities, the same ones I mentioned that are sort of obvious candidates for 1A. Montpelier, Chittenden County towns, Brattleboro, Rutland. To name a few, they do have wastewater facilities that have a lot of dry weather capacity, so we invested a tremendous amount of money in these facilities. So they could accommodate hundreds of thousands of gallons more wastewater to treat properly during dry weather. But they were designed, in part because EPA encouraged this, to accept stormwater, because the idea was we had a stormwater problem. And there was no treatment for stormwater. We now have better stormwater programs, as you all know. But think back to the 1970s, the 1960s, where we really were doing a terrible job with stormwater, so. I think the thing,
Into the water line.
yeah, it just ran right off, so the theory was, well, why don't we collect it and send it to the treatment plant, that would be better. And it was a real miscalculation, but also climate changes have affected this, right? Because if you didn't have really crazy rain events, maybe it would be okay. But now we have regularly these really intense rain events, they overwhelm the plant, and raw or partially treated sewage is going into the waterways. BRC, following this debate for years, we get the notifications, you can get on the notification list every time there's CSO, we get those notifications.
My
It's bad.
phone, my text,
Yeah,
it's
bad.
raining and I know it's raining hard.
So we actually started looking at wastewater permits that, to see how they're dealing with CSOs, and to our chagrin, we found that there aren't, in our opinion, the conditions in the permits were not adequate to deal with CSOs, and they were not following the law, in our opinion. We appealed the Rutland NPDS wastewater permit. We have an appeal right now that's ongoing in court, we're waiting for a decision. Because the conditions in that permit, there were no CSO conditions in the permit essentially. The conditions basically reference you to these enforcement orders that ANR has, and these long-term CSO control plans. That the Rutland plan, for example, EPA required these plans to be created starting in 1994. The Rutland plan was just adopted in 2022. So I was really shocked when we got into this. So I think the issue is we are not doing a good job with CSO. ANR keeps on saying that we're doing an okay job. The Rutland case shows that's not true. I'm now doing a evaluation of, there are 12 facilities overall that have CSO. So I'm looking at all of them, and now that I've seen what Rutland is doing, want to see that the other ones have these long-term control plans. I know none of them have conditions in their permits. That's the legal fight we're having with ANR. ANR saying we don't have to put the CSO conditions in the permit. We're gonna require planning to do it, and we're gonna use our enforcement authority. And we're saying, no, the Clean Water Act says, first of all, you're way late on the plans, and secondly, you gotta put the conditions in the permit, so we have pollution limits. So there's accountability to the public to comment on these permits. And under the Clean Water Act, you can actually have citizen enforcement of permits, which you don't get under state permits. So it's ANR saying, no, none of that applies, we could use these other mechanisms, and we can do planning instead of the permits. So that's the legal fight. But I do think there's an issue here. I think the issue is doing better with permitting. Money is the issue, Senator Watson. We, with the ARPA money and the COVID money, and the infrastructure money, like we recommended spend as much as you can on CSO, because this is an opportunity we're not gonna have again. We're not gonna have hundreds of millions of dollars again. And we spend more money, I think spent like 30 million more, which is great, but it's not enough. It's still not enough.
There we go.
In your history, it
Yeah.
was about 1980 that the revenue sharing changed. was available for, a couple decades to help people build the sewage plants dried up, and we added that, and that is what kind of jump started the problem for them.
So I think it would be appropriate, so this is the conundrum, you see the conundrum, right? Like we need housing in Montpelier and Barry and Rutland and Brattleboro and White River Junction and Burlington and Colchester and Essex Junction. And those are the areas that have these plants that have these problems. They have this dry weather capacity. They're not doing a good job, in my opinion, on CSOs. How do we kind of marry these things together where the policies of the tiers 1A and 1B, which I think are good policies, we're not doing a good job on the CSO issue. I think it's appropriate to put some provisions in there to move the CSO issue along, and we should talk about how to do that. And I think you should have A&R in, and we can have a debate about how well or not well they're doing. But to me, like I said, it's pretty clear that this is not going well, and fast enough. But that's the tension.
Well, thank you, it's great that you know that history.
Yeah.
And would you be willing to write some, like where draft?
Sure, I'll give you all I'll give you some of my briefs that I wrote for the report, but I'll boil it down.
Well, not just, but in addition to the brief would be great, because then it helps people who me, who won't remember everything you've said, like read it a second time, but in terms of language, we might consider adding to the bill.
Yeah, I'll think about it. So that's how I see the issue, and it's a legitimate issue, and it really is conundrum, as I describe it. In my opinion.
Senator Watson?
Thank you, I mean, it sounds like we're already going down this track, and that's fine, in terms of like having some language from you about this, just thinking about the qualifications for a municipality to get this, the tier 1A sort of designation. I guess I would just say like, having, I just want it to be like workable, for these places, right? Like having a plan, moving towards the plan. I'm okay with progress, and not perfection. But that's just where I'm at.
I hear you.
Did you say tier 1A?
Tier 1A, yeah.
Oh, I'm sorry, I said it's tier 1A.
Well, maybe they need tier
Not
1A for their CSOs.
So I hear you. I mean, like, get all the facts, but yeah, no, it's a conundrum. It's two competing things going on, right? That we have problem. Like, if you said in Montpelier, like, you can't hook up any more homes, right? And you need more home, it's right. It's like those things are in.
Oh, totally.
Conflict,
Totally.
So, but it is a real issue, and I looked at it and I was shocked to find what I found.
This is new information for me also, so
Yeah,
thank you,
yeah.
appreciate it.
I learned a lot, and it's been quiet, I've been grinding down for it, because like, it's a. We're just briefing, and no one, the lawyers read them, and the judge.
I'll take a shot, guys.
But I mean, it's relevant, so I feel like I should bring it up, because we're gonna get a decision at some point, and at least clarify the legal part of it, but that doesn't answer the policy question regardless, right?
But, our challenge in here to know is that we're always speaking up for the environment, which doesn't get to come in here and testify. So every time there's a problem, like how would you make something cheaper by externalizing a cost? Oh, well, we'll go ahead and there'll be some environmental degradation, and we'll decide it wasn't undue adverse impacts, it was intolerable or something.
Yeah, no, absolutely. So just moving along, because I want to tier 3 for Senator White, who's not here. So the bill does not have tier 3 in it. So that needs to be reworked. What the bill has in it is, and this is because this is mirroring House bill. It has a definition of critical resource area, and this is how the bill defined it. It's a river corridor, significant wetland, any development over 2,000 feet, development on steep slopes above 15%, development in prime ag soils. That's the definition in the bill, and there's no tier 3 in the bill. We support the NRD approach of tier 3 as opposed to that definition of critical. And basically, so there's that definition in the bill, and then the bill says any development within 25 feet of one of those resources would trigger Act 250. So we support the tier 3 approach. We can talk about what should those resources be, like we talked about with Charlie earlier. I want to say again, I think like with river corridors and wetlands in particular, and riparian areas, we think S213 is the right approach, like create the state program. That's why it's really frustrating for the state to come in and say, we can't do it, you just can't do it. If you don't do it, if they don't do it, then I just say like, well, then have Act 250, then you just say, well, Act 250 jurisdiction should be triggered, those should be tier 3 resources. But the question is, do we need to apply all the 10 criteria of Act 250 to review of development of river corridors and wetlands, but we really want to make sure that there's no harm done to the river corridor and flood issues, traffic and aesthetics and all the community growth issues. That's Act 250. Like, is that a good use of resources to do that rather than having a statewide program that is, which they know how to do as you've heard with 213, right? Got the model bylaw, they know what to require, you know how to improve the wetland regulations. So those are the two approaches. So the bill is drafted takes the approach of we're going to use Act 250 and pull in wetlands and river corridors into Act 250 versus S213. So again, here's those two things.
And can you
Interact.
explain, so what are the mechanics of saying that we have a critical resource area, but we don't have tier 3? I mean,
This is basically defined
I
like,
think the nomenclature needs to be sorted out.
yeah, so it does call them critical resource areas and list them that way. And it's automatically applied to Act 250. Rather than saying, there'll be a planning process, like with 1A and 1B, the way the NRB report works is like, we're gonna let the regional planners through their future land use map says, here's our mapped areas like that we think qualify as 1A, here's what qualifies as 1B, here are the tier 3 critical resource areas in the town. Now let's send them to the new environmental review board for designation. And then Act 250 will either apply or not apply based on that. The bill just defines them and says Act 250 in those areas.
The areas you just listed, aren't they already covered under Act 15? Aren't they already given attention?
They're covered as criteria, but not jurisdiction. The issue is that a very small percentage of, development goes through Act 250. So if you're in Act 250, you have to address impacts on floodplains and river corridors
Yeah,
and wetlands, but that's only like 20% of the development in the state. So that's why S213 would say, no, we need to protect these areas more broadly. Can't just rely on Act 250. This bill would say, the way it's drafted, would create Act 250 review for any development in those areas. But right now, you only get to review if you're in Act 250, you're not in Act 250 most of the time.
what about the length of driveways and what about elevation?
So, yeah, I mean, the elevation we've talked a lot about, and we should have like Jamie Fidel come in and talk about the elevation issues. The NRB report didn't recommend that. It becomes controversial because and we can show you the maps, because if you do a pure elevational analysis, you pull in a lot of the state into development and
Ripken,
Yeah.
I think it's at 1800.
and then it becomes a question, is that like, what we like about tier 3, if we do it right, is based on planning, right? It's not just saying, okay, you're above 2000, everything is in. It's like, are you, and this gets to one of the tier 3 resources, we think they should be significant forest blocks and habitat areas and natural areas and headwaters and class A designated waters, like we talked about, last year.
Anti-day.
Right, anti-day, but it'd be based on planning and mapping of those resources. Rather than just saying anything above 2,000 feet, you pull in, but they're both, have validity to their approach, but there are different impacts in terms of the amount of land that you're regulating. Is it the best, how do we use our resources? Do we apply Act 250 just broadly there? Or do we do this kind of planning analysis, like here's the critical resources we want to protect through Act 250 and pull them in? Based on the RPC mapping and analysis, working with A&R, basically. So those are the two approaches that you could choose. The road issue, which is a road rule, which is in tier 2. So basically, what the road rule does is, because tier 2, as you heard from Charlie, is such a wide area. It's the widest area. Tier 1, Chris Rockman said it was 6% of the state. You don't know exactly what tier 3 is going to be. The vast majority of the state is going to be tier 2. It could be a lot of development in tier 2. There is now, that's especially fragments forest. The NRB report recommends the 2,000 feet cumulative road and driveway road roll, try to encourage developments to pull back from the forest areas cluster. That is in Ellen's draft. Ellen did draft that. We talked about on the steering committee, like, if we went with the 2,000 foot cumulative road, what if you had one single long road kind of jutting off into the forest? And we're concerned about that, and there was not consensus on the NRB steering committee about whether we also needed a single road trigger. We think you do, and we'd like to put that on the table for you to consider. The old road rule was 800 feet from a road. So we're thinking you can have 800 feet from a road. If you go 800 feet out from a road, you would trigger Act 250, and if you have 2,000 feet cumulative of roads and driveways. The House bill right now has 500 feet from a road. That's what they're working with, just so you know those conversations are going on up in the House.
And that's from any road,
What's that?
from any
From
road.
any road, yeah. Right, so anyway, so that's just, so Ellen has the 2,000 foot cumulative road roll. We'd like to, when you take that up, talk about maybe a single use road, but that's something that we can work off, and that's really important in tier 2, this widest swath of the state. I do want to note, like, and you should have other experts in on the, we get hung up on the percentage of areas in tier 1 and tier 3. Whatever the percentage of areas are now in and around our downtowns and village centers. That's where most of the development is in the state, so it's maybe a small land percentage of the state, but most of the development is right here in downtown Montpelier. And down in and around downtown Burlington, in and around downtown Middlebury, right? Even Little Lincoln, like that's where most of the development is, right? So it's a really, I don't think it's a really good measure. It's very last year we had a big debate when we came into the housing and go, oh, it's only this percentage of the state that you're applying these exemptions to. But it's around where we're already building, you know what I'm saying? Do we really want to say, oh, let's widen it out so our headwaters and our forests and let's bring in just more land because we gotta get that percentage up. So I think that's a false sort of way to analyze, or not an accurate way to analyze this.
Not such a useful measure.
Yeah, it scares people or bums people out because they want to see a higher percentage.
Requirement.
Do we have any solid information? I know I certainly hear opinions, the coffee counter. Do we have any solid data on just where people, given their druthers, would live? Because I've got a sense that some of my neighbors are right, that we're encouraging all this downtown development, but people actually want to live out in the country. You're thinking, and it strikes me that what will happen is that we will exacerbate our problems of exclusion and inclusion and inequity that will have the more affluent people living out in the country because they can still afford it and they can make that work. And then the affordable housing will all be downtown, occupied by people who probably would not live there if they could afford to live out.
Yeah, you should have some, John Adams did a great presentation on this a few years ago, where the data, it hadn't been, I mean, this is from my memory. Younger people actually want to live closer to downtown where they can get on public transit, they don't want to own cars, and they want to be more community oriented. That's the data, as the generations are shifting. When we talked about this a little bit in the NRB steering committee, and our feeling is that yes, rich people can build wherever they want, and that's not going to change. We can't, and the idea behind this approach is let's not encourage rich people. They want to do that, fine, but let's not incentivize that. But I think Vermonters who own a lot of land and may not have a lot of money, they still, if you own in your family 100 acres and you wanna build a house for your sons, your daughters, and subdivide, 10 acres or 5 acres or 20 acres, you can still, nothing in here would stop that from happening. And actually, when you can avoid Act 250, nothing in here, as long as you're not building in a critical resource area. And I think we would want to address that, just avoid that don't build in the significant forest block and, too close to the headwaters and, you can still do it, if you have 100 acres, you could avoid those impacts. And you don't need an 800-foot road, a driveway, or 2,000 feet of roads and driveways, trigger out, you can avoid all of that. So I do think that I don't think we're really making it harder for people. I think we're saying, we're helping them, we're like, you want to avoid this. And we're telling you that these things are here, you can still do it, and you'll do it smart, and you'll do it in a way that will help us adapt to climate change and, not have these impacts.
But our effort, I'm wondering if our efforts to encourage downtown development. Our efforts to encourage something that's happening anyway is going down.
Well, I think we need I don't think Act 250 is causing this, but like, we need the market to shift, we need people to build housing in these areas, for people to go to. But I don't think Act 250 is, and I don't wanna say that up front. I said it before, I don't think Act 250 is the problem, Act 250 can cause the housing crisis, Act 250 won't solve it. Like, the way we look at it is like, if we can encourage good planning and development, and we could incentivize the use of infrastructure that we've invested in, we should do that. We should do that, but this one, we need, and I'm not an economist, and I don't know what it will take to get developers to. Not build, big mansions out in the countryside and make $1 million versus build multifamily housing in and around. Our downtown areas, but that's. I don't know what to say.
Thank you for your comment. Act 250 did not cover.
No, I don't think you
Act 250, so weakening Act 250 in the name of affordable housing is going to result in a lot of disappointment.
Yeah, I mean, again, but I think the NRV approach is a smart approach. It's like, if we can have good planning and be better protection, Act 250 is not doing a great job of protecting critical resources, and it's just not, it does not get jurisdiction over most things, so I think it makes sense to do, but no, the problems are way well beyond Act 250. I know I'm running out of time, so two quick points I wanna make. One is, we'll give you comments on the process.
Yeah.
I think the NRV report and the RPC land use maps, they don't really bridge like efficiently kind of how that mapping work gets done and how the designations get made. There seems to be a potential for a lot of redundancy. We want to work on language in the bill that would basically say, the RPCs do all this great mapping and get it very reasonable in 18 months. Let's use the mapping. And let's not go back to the towns and let the towns say we want to change it before, like, that should go to the board. And we should, because otherwise we won't get locational jurisdiction. To the point about basin plans before, to your point, we identified important wetlands, class A waters, they don't get designated. They're just in the plan, they sit there in the plan, and, so there's a danger of that happening if you don't streamline and be clear about the process, and we could provide language around that. The last thing I want to say is, what's not in the bill is the forest fragmentation criteria, which was recommended in the, you report, and I think you passed it 27 times. Hyperbole.
It's a groundhog day. For sure.
So yeah, that should be, Ellen should add it in, and we would recommend using the version from a couple years ago that the governor vetoed that bill. And we can get you that bill if you want, but that was sort of a version that there was a lot of consensus around. I think it's consistent with the NRG report.
Right. If you could, share what you've shared with us in whether it's note form,
Yeah.
draft form, a combination of the two, that'd be great, because you are deeply engaged in all this, know a lot about it, so it's hard for me to appreciate fully everything that you're saying, and we don't understand that much time at the moment, so that would be great. Now, Watson, you had a question.
I did, I just wanted to say that, a map that I think might be really interesting and helpful, and I'm not recalling seeing it, I could be wrong, is a map of where, like, the clusters of Act 250 applications. So, with this question around like, okay, so only, X percentage is tier 1A, so only X percentage is tier 3. So it might be interesting to see, okay, well, here's sort of the clustering of where Act 250 permits are being applied from, and how that maps up with, potential for like the percentage of areas. So I'm guessing that you have this map.
It would be hard to put together. NRV would probably,
How about permits?
yeah,
We get
Sure.
permits.
Yes, yeah, right,
If we have that
that would
few
be,
years, but.
I think that would be helpful in, particularly with our colleagues, in illustrating that like. The percentage of land that we're talking about, though it might sound big or small in these areas, like this is where we're talking about.
yeah, no, that's a great suggestion.
Right, the other, Jill, I'm wondering, I don't know if we formally made a request or, of NRB to give us an update on, since July 1, how many PHP, projects came forward, or, or how many projects came forward that are taking advantage of the changes we made in this one. It's like, but if we turn the my opinion is that if we turn the thermostat, then the temperature and the labor source at all, I don't know, maybe it did, we did, it's developed. How effective, especially because we're relying on them to buy us time to ramp into what we're talking about here. Okay.
Yeah, we've done, annually, I think for the last several years, PFP, kind of spreadsheet or happy to send that over when it's finalized. I think we're close, if not there.